Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. Today we're going to talk about trademark law and how it works. So a trademark is any word, symbol, or other device used to distinguish a business's products from other businesses. There's both federal and state trademark law, lots of statutes on the federal and state level, but basically federal law is coextensive with state law and it's broader. So whenever we talk about trademark law, we're usually talking about federal law. And the operative federal statute is the Trademark Act of 1946, which is also known as the Lanham Act. But every state has different state laws. Trademarks also overlap with the deceptive practices laws and unfair competition laws. So you definitely talk to an attorney if you have questions about a trademark dispute. But overall, we're talking about federal trademark law, the Lanham Act, that lays down the basic rules. Let's talk about what types of trademarks are protectable. Brand names, logos, and trade dress are the big three categories. Brand names and logos are easy. Trade dress is basically packaging. So in order for anything to be trademarkable, it's got to be distinctive, meaning that the mark distinguishes the owner's goods or services from their competitor's product. Trade dress, in addition to being distinctive, has to be non-functional. So basically that means an example of trade dress is a Corvette, the way a Corvette looks. Now you can't call the motor trade dress, but you could put little wing flaps that are non-functional, call that trade dress, and trademark them as opposed to patent or copyright. So the next question is my trademark distinctive enough to be protectable? This is the fun area of trademark law. So basically, word trademarks are categorized based on how distinctive and unique they are. They fall into one of several categories. And some of those categories are automatically trademarkable. Some of the categories are trademarkable in certain circumstances, and other categories are not trademarkable. So let's go over the categories. This is kind of the fun part of the episode. Coined words are artificial words made up by the owner of the mark. So they're brand new words like Google. That wasn't in the English language before Google came around. That's an automatically trademarkable type of word, is a coined word. Fanciful words are words that are in the English language, but the trademark owner put a different spin on them. So cheese whiz, it's a playful, a fanciful take on an existing English word. Those are also automatically trademarkable. Arbitrary words are words that are in the English language, but really have nothing to do with the product. So Apple computers or Old Crow whiskey. They're using real words, but they're not descriptive of the product at all. Those are also almost always trademarkable. Here's where we get into the fuzzy areas. Suggestive words don't directly describe the product, but they imply a quality of the product. So Greyhound buses is a suggestive trademark. It implies speed that's associated that Greyhound wants to associate with the product, because Greyhounds are fast. They want to say their buses are fast. It's a suggestive word. Fast buses would not be subjective. That would be directly descriptive. That would be a different category. But suggestive words, where it's not directly describing the product, but takes an extra mental step to get to a description of the product, are trademarkable based on the factual circumstances. So unlike the categories we talked about before, you can't automatically trademark those words, but based on your specific product, you may be able to. Descriptive words is the last category I want to talk about, and this is something that just simply describes the product. So this is something that says, for example, comfy. If I tried to have a product called comfy slippers, that trademark would be denied because descriptive words aren't trademarkable. You can't just say, great tasting vodka. When you're just describing the product, it's not trademarkable. Sometimes, if you have a descriptive word, you can get a trademark based on you being so dominant in the marketplace that the word takes on a secondary meaning. So basically, when people think of your trademark, your descriptive word, comfy slippers, the first thing they think of is your brand, not slippers that are comfy. So descriptive words can be trademarked, but you've got to first establish yourself in the marketplace and become kind of the dominant thing in people's minds when they hear that trademark. And I said that was the last category. There's one more category, generic words. These are never trademarkable. These are basically words that just are the same as the product. So if I had a television company and I wanted to call myself TVs, I couldn't do that. It's even worse, harder to trademark than a descriptive word because it's not just describing the product, it's just saying what the product is. If I had a camera store and I just called myself Cameras, I would never be able to trademark that. So how do you find out if your trademark is available? This is really important to do. A lot of people put a lot of money and time and effort into branding, and God forbid you do all that and you find out later that someone else has the trademark and you have to undo all your branding and stop using your brand. So before you start your business and do any branding, you or your attorney probably to review federal registrations and applications, state registrations, trade directories, and publicly available business records. USPTO.gov has that's kind of the first go-to place. They have a database of federal applications and registrations. But you want to look all over the place because, as we're going to talk about soon, you don't have to register to have a trademark. So you want to kind of Google around, make sure nobody else is using the business name. If you do this, if you perform a trademark search and you're later found to have been infringing on someone else's trademark that didn't come up in the search, the mere fact that you performed the search can be serve as a proof of good faith as a defense to any damages if you're later sued for infringement. So let's talk next about the priority of trademark rights. The first person to do one of the following two things has the rights to the trademark. One is to continually use the mark in commerce. So if I'm the first person that's using the mark in commerce, and we'll talk a little bit about what that means, then whether or not I've registered my trademark, I have the right to use that, at least in my geographical area that I'm using the mark. The other way to get priority is to apply to register the mark, and then after you've made your application, start to use the mark in commerce. So just to play this out a little bit, in a situation where I've made my application to use the mark, and then someone else starts using the mark, and then later after they've started using it, even though I filed my application first, I, after them, start using the mark in commerce. So I'm the second to actually use it, but I was the first to file. I would have priority over the person that just started using it. If the person that just started using it without filing started using it in commerce before I filed my application, then they would have priority over me. So when you, basically the two ways to obtain trademark rights is to use it in commerce or to file and use it in commerce. If you just use it in commerce without ever registering it, that's called common law trademark rights. These are, again, specific to the geographical area you're actually using it. So if you file a registration, you've got nationwide trademark rights. If you're just getting these common law rights just by using it, they're specific to the geographical area you're using it, or sometimes you can expand that to your natural zone of business expansion, where you're likely to use the mark. So the next question we want to answer is what constitutes use in commerce of a trademark. So, we said either way, whether you register or not, in order to get a trademark right, you've got to actually use it in commerce. A mark is used in commerce when we're talking about goods if it's placed on the goods or their containers or their displays, tags, or labels, or if all of these methods are impracticable based on the type of goods, then on documents associated with the goods, with the sale of the goods. And in addition to the mark being shown on the goods or in the documents associated with the goods have to actually be sold or transported in commerce. So if that happens and you do that and nobody else has filed the trademark registration first or nobody else has done that first, then you have the trademark in those goods, a common law trademark anyway. A mark is used in commerce with respect to services when it's displayed in sales or advertising materials for the services and services are actually rendered. So that's how you can establish a trademark. So if you can get a common law trademark, a lot of people ask themselves, why should I register my trademark? I can get a trademark just by using my trademark in goods and services, and I can get at least geographic rights, which is usually what most people care about. So even though registration isn't necessary, there's a lot of benefits to doing so, and it's really highly advisable. So we said earlier, a common law trademark, one that you're just getting without registration, just by using the mark, those trademarks are limited, your rights are limited to the geographical area you're actually using the mark in. A registered trademark, you have nationwide rights. Federal registration, if there's ever a dispute over who owns the rights, federal registration gives you prima facie evidence that you have the trademark. So the presumption is that the trademark is yours. Someone else has the burden of proof to prove that they actually have the rights and that they were using it first, which can be hard to prove. It's hard to prove when you started using mark. So it's evidence of the use of your mark if there's ever a dispute. It also provides notice. Registration provides constructive notice of your claim. So this is effective whether your competitors actually look at the registry or not. They're deemed to have notice, and this can have an effect on the outcome and damages associated with later lawsuits. And we talked earlier about how if you do a registration search, you'll have been shown to have acted in good faith. Well, you can't show yourself to have acted without notice in good faith if your competitors already actually registered their mark. In some cases, such as counterfeiting, registering your mark provides you additional remedies over and above what common law marks would give you if there's ever a dispute. After registering the mark and using it for a continuous 5 years after it's been registered, by filing an affidavit, you have the right to make that mark incontestable. So basically, once you register it, you use it continuously for 5 years, you do a second filing, and nobody can contest your use of the mark. You can head off any litigation over who's got the right to the trademark. And finally, federal registration provides an absolute bar to claims of trademark dilution. So there's a lot of benefits to registering your trademark. It's not terribly expensive to do. It's pretty easy. You should definitely do it through an attorney because it's something that you have to do the right way in order to do it successfully. The process is basically you file an application with the U.S. Patent and Trademark Office and attach copies of your mark and usually evidence that you've used it in business. And once that application has been filed, it usually takes 3 to 6 months before we hear back from the Patent and Trademark Office's attorneys. They'll review the application and let us know whether it's approved or whether they need to take an office action and modify the mark in some way in order to get approval. So they'll say, here's what we need to do to change this to make it an acceptable trademark. Are you willing to do that? So we'll communicate with the attorneys, we'll talk to our client and make sure that they're okay with that change, and we'll give the Patent and Trademark Office the go-ahead to do that. And if we do, then it'll usually be approved after being modified. So it's pretty painless process. It takes a couple months to go through, and at the very least I recommend doing a trademark search to make sure you're not going to be bumping into anybody else's branding and have to change that. So if you have any questions or if you need help with your trademark or any other business issue, or really any other area of law, we have 5 attorneys. They're all great. They all practice different areas of law. You can call us at 630-324-6666. The 630-324-6666. We offer free consultations. You can also go to learn-about-law.com for articles, videos, and podcasts on almost every area of law. And we have a more in-depth article on this subject too. If you want to check out our business podcast where we interview business owners about the secrets to their success, go to seizeyourbusiness.com. And you can go to makingrealestatefun.com for our new podcast about real estate and suburban lifestyle. So thanks so much for listening.